Welcome to the GCI Conference Center. Thank you. Please stand by. You are being placed into conference in listen-only mode. There are 25 participants in the conference.
Okay, we are back on the record. Computers is 113. We on a control board. We are on tab 7. NOVs issued and licensee responses. Who wants to take that? This is generally an information item for the board. Yeah, James, you wanna not go through all these individual, but any you'd care to highlight? Go ahead, James.
Mr. Chairman. I apologize. It's been pretty busy past couple weeks, and between this and the alcohol board, going through the NOV is kind of the same thing that I've said before. Is there are some that are very concerning. I think those are self-explanatory, and those tend to be the ones that you guys address later during accusations. There are some pretty serious allegations with Houston Gas Station and Common Collective in these NOVs. I do want to point out there is responses. The investigator does have an investigation that he still currently is working on prior to us delivering all of our finished investigation to the director. You probably won't see anything regarding this until after that occurs. It's been an ongoing, extensive investigation. Other than that, unless the board sees any specific NOVs that you guys have questions about, I don't have anything else I'd like to highlight. Is there...
Board members think about any of the NOVs, tab 7.
The Houston grass, can you elaborate on those NOVs?
In short, Investigator Rux? The investigator for these NOVs is here present, rather than being the, voice, the delivery, and inaccurately speaking to something. I would much rather have him answer the question.
Yeah, go ahead, Chris, good question.
Just the case in general. Can you talk about what happened there?
So Ron Bass, the owner and licensee of Calm Collective in the Houston Grass Station, was transporting a large amount of marijuana to an out-of-state destination. I believe it was Washington. And the TSA stopped him, and airport police, they had seized the large amount of marijuana, and they notified us. Said yes, he is a licensee. He didn't have a manifest. He said it was for his personal use for out of state. It was over 4 ounces of marijuana, though, which is outside the 1 ounce of personal use, which is normally the standard for which people are allowed to transport. Among other things, there was some vape cartridges, some other joints, individual joints in cylinders. Those things were outside of the 4.6 ounces of marijuana. So yes, we told the airport police that yes, he is a licensee. They said that there was no manifest. It was for personal consumption. So they actually had submitted charges for the large amount of marijuana, which I believe was dismissed or not charged by the prosecutor. Submitted it to. And so we were interested in some of the aspects. I went and looked at the evidence that they had taken. So we were interested in some of the packages, and so do you have something to add?
Yes. All of these were allegedly taken from his retail marijuana store and from his cultivation facility, in which we've requested video from the cultivation facility for the removal of the actual marijuana. And when we asked for them to produce that video, they said that video was erased or not. It wasn't provided to us based off of that specific only camera going out due to plumbing issues. And that was a camera that was reported to us that showed Mr. Bass removing the marijuana from the facility.
So I did request video of the Calm Collective facility, the drying room where they store marijuana, because there were some markings and stuff on the packaging which made it look like, there was metric tags and stuff. So I wanted to see if it had come from there. They had a plumbing leak earlier in the year, and the plumbing was in the grow facility where the plants were being grown, and I guess a sewer pipe on the wall ruptured and sprayed all their plants with sewage, but that's a different topic. But it was outside of the enclosed drying room. So I went down to the facility to look at the drying room. There was no water damage anywhere. None of the plumbing around the drying room had been replaced. There was one camera in there, which he said was ruined by the water from the sewage leak. It was not ruined by the water for the facility. It was still operational. But when viewing the cameras, there was only 21 days saved on that one specific camera. The rest of them were recording other video further than that, with it close to the required amount. Another thing about the cameras is that they weren't in compliance anyways. They were on a Vivint system, which is saved on a cloud server. They only record. They don't continuously record. They only record when there's motion or when a doors open and disrupt one of the door sensors. So we didn't get video of the drying room. It obviously wasn't due to the sewage leak because there was zero water damage. The camera was still operational. It was just gone. Okay. So talking to witnesses since then, they say that it was deleted. They witnessed it. While we're there, viewed the visitor logs. Can you pull that one up? So the visitor logs were incomplete. They're supposed to record the name, date, time in, time out, I believe, and there was a large number of those. I think it was ballpark was like only 73 out of 140 something were correct. So less than half of them were actually correct.
Mr. Chairman, members of the board, the common collective NOVs that you see they were in the last board meeting provided to the board without responses at that time. The ones that are in here are provided responses this time. They have not responded to the visitor log NOV that was issued at the same time these were issued. That's why you don't see it in here. So that one, as Investigator Ruggs has pointed out, was, in our opinion, very egregious. And the numbers of the entries versus the manifested and made up names within the log were very concerning to enforcement.
And then there was another NOV for not wearing visitor badges. There was it looked like there was a rap video being made at the Common Collective facility, and the people on camera weren't wearing visitor badges. I was witness on another occasion that the employees weren't wearing employee badges. Okay, so I think I briefly mentioned the packaging that he had at the airport. Some of the joint containers, one of them had a metric tag on it that had met the regulatory requirement. There was 3 or 4 others that did not. And when I spoke to Mr. Bass, he stated that when you purchase multiples, you get one with a sticker on it, and then they give you a printout of stickers for the rest of them, which the reg clearly states that they have to be stuck onto the packaging, or the packaging has to be labeled with the warnings and the metric number and the facility and stuff like that. What else we got?
Mr. Chairman, this obviously, there's a lot of detail that Investigator Ruggs has put forward in a report that he will provide to the board at some time. I hope he hit on the high points, as I think that these are some serious issues that we do believe need to be addressed. And as soon as we can complete our investigation, we will bring it to the director, and I believe that you guys should hear from us, or hear from the director shortly after.
Okay, thank you. Any questions without delving into much of the detail and what they reported, because it is still part of their report that's got to go to Schulte.
Just one quick question, and I'll wait for the report to get into the real details. But the approximately 4 ounces of material that was being taken out of state, was that bud, flower, seeds, combination?
It was mostly bud, I guess bud and trim. Whatever was in the joints, I'm assuming it was trim. That's normally what's rolled in the joints.
Okay, because I see reference to seeds in here. I was trying to figure out if that was...
There were some seeds, too, with metric tag numbers on them. That was a separate issue, actually, that I don't think I touched on. So the seeds were in a little baggie with a metric tag number on it, which came back to the Houston Grass Station, which was a trim bag, which was They use these, they'll write the tag number on it. Trim gets lower with making products. The seeds were left, but the issue was they were removed from the facility. They weren't wasted, or they weren't, transferred to another licensed facility.
Thanks. All right, good, thank you. Anything else in the NOV report you want to touch on, or we?
Nothing that we're not going to discuss on the next tab,
Okay.
I believe.
All right, thank you. Okay, then let's move on to tab 8, which is an NOV for licensee 16610 Great Northern Cannabis. Okay, go ahead and introduce yourself for the record. There you go.
Good afternoon, members of the board. Director McConnell. My name is John Redden. I'm General Counsel for Great Northern Cannabis. Spelling is Redden.
Thank you.
Mr. Chair?
Yeah.
Before they begin discussing this, I would like to let you know that Great Northern Cannabis did, in their NOV response, request this hearing for the board, and since they have the right to request that, I assumed it would sort of be obvious it would be on the next agenda, and I did not give them proper notice of this. I only sent them an email yesterday evening, so I apologize for that, and would like to
Okay.
In regard to that,
Yep.
we would just like to make a record and reserve the right for appeal purposes in case that were an issue.
And all we're looking at, we're just still NOV. It's not an accusation. Chief, you want to review the NOV with us, and then we'll go to you, sir.
On September 10th, 19, we issued an NOV for Great Northern Cannabis conducting weekly games of quote-unquote Plinko at their Diamond Boulevard retail store. Customers were provided a Plinko chip to drop onto a Plinko board within their licensed premises. The customer was given a voucher corresponding to the final resting place of their Plinko chip. The vouchers contained various monetary discounts on marijuana products and other products available for sale in the retail store. The customer was then able to redeem the voucher at the point of sale. The surveillance footage was reviewed from inside the retail store and confirmed that this game was taking place on 8/13/19. I believe this happened every Tuesday. AMCO had received reports of lines lining up outside the store and people curious as to what was going on. I had conducted a walkthrough of the business. I believe it was either the end of August or the beginning of September, and I had learned about the game that was going on, which kind of piqued my curiosity, and I got a follow-up complaint the following week. And they were written a violation for 306-770 K12 signs, merchandise, advertisement, and promotions, and without reading directly from the regulations, basically promoting overconsumption of marijuana.
All right, thank you. So, Counselor?
Thank you. Our written response pretty much stands on its own, but I would just reiterate the fact that 306.770 K1 and 2, just to read the code into the record, is a licensed marijuana establishment may not encourage the sale of marijuana or marijuana product. Number one, by using giveaway coupons for marijuana or marijuana product as promotional materials. And point two, by conducting games or competitions related to the consumption of marijuana or marijuana product. As provided to the board in my written response, it's very clear that none of the coupons that were randomly distributed to customers at Great Northern Cannabis included any giveaway coupons. They all required the purchase of cannabis. They were simply a method of randomly distributing a potential sale to customers. And secondly, I would readily admit that the Plinko is a game, and it's related to the sale of cannabis, but not the consumption. We weren't encouraging consumers or potential customers to consume any more than we were encouraging the sale. Sort of my thinking of what this regulation probably sort of the intent of it would be to it's very clear that the game was being used to encourage the sale and not the consumption. We don't have a endorsement for on-site consumption. There was no consumption at the facility, and that was not in the notice of violation of any suspicion that was taking place. So I think that you all probably come to the same conclusion that we did, that we were not in violation.
Mr. Chairman, I do agree that they did not give away free marijuana. And I guess my question would be, even though this promotes a sale, why is it here? There's a separate section for on-site consumption. Why is it in this place if the sale doesn't quantify the consumption of marijuana? Is promoting more sale of marijuana the promotion of the consumption of marijuana? I mean, I guess that could be considered a stretch, but I guess my ultimate question is, why does this section exist in this area, if not to address this?
Well, you know, I think that one of the key phrases in 770K is give away the, it doesn't say the sale, it says consumption or coupons that give away marijuana. And the way I'm looking at the rules of this, got to be 21, okay, no purchase necessary, okay, participants must agree to a hand stamp, which I guess is to keep track of who's played. One play per day, and maybe you'll win, down here to the picture, maybe you'll win a $1 for a pre-roll, or $3 for a pre-roll, or 20% off of one item. Does that mean a licensed product, or would that be a T-shirt or a hat? So it's 20% off of one product.
Yeah, I think it's
or
up to
one item. I'm sorry.
Yes, it's up to the discretion of that particular coupon relates to this. It's at the election of the customer.
Sure.
Yeah.
Okay. And so money is changing hands here, and you only get to do it once a day, and you may be in there to buy you wouldn't, I guess you'd have to be careful to make sure somebody doesn't go over their legal limit by playing Plinko and then making a purchase. Do you guys keep track of that?
Well, the same way we would for any other sale. So the sales are taking place, and we're keeping track the same way we would with any.
Okay. Sure. And James, do other establishments advertise or offer discounts on marijuana products?
In the way of like a Plinko game or some other game?
No,
they do. I mean, absent our regulations is pricing and marketing.
Yeah. Yeah.
So I mean, it's absolutely concerning that I guess I come back to, if this has no intention, giveaway coupons is the same as free marijuana. Why didn't we just say free marijuana? We use different terms in the regulations, and it gets extremely confusing. And, you know, I guess you can draw a line from it and say if somebody was given a coupon or a chance to play and absolutely win something, would they purchase more marijuana? If that was related to another substance, would that cause an overuse or overconsumption? I know this all comes down to an individual's choice, but it certainly does not help when you allow for an individual to play a game to be able to purchase more than what they may have originally intended.
Through the chair.
Yeah, go ahead.
Through the chair.
Oh, I'm sorry, yeah.
If you go back and look at the notes from previous meetings, we've had this discussion, and I believe the director and I worked on these regulations, and one of the specific things the reason we put consumption in there was to give businesses the ability to advertise and do different promotions as long as they weren't consuming marijuana on site or, smoke a gram, get a half a gram off, right? So that's the reason consumption was specifically put in there, so businesses have the opportunities to have different promotions, different advertisements. This is, the intent of the regulation was to allow things like, not particularly Plinko, but whatever they wanted to use to promote their business without saying, without consuming marijuana or putting a limit that they have to consume a gram to get a coupon and things like that. So I agree there is no NOV here, and being a drafter of those regulations and a lot of the conversations we've had in this meeting, if you go back and look at those notes, I'm sure it'll clarify it.
Yeah, I'm having a hard time reaching the conclusion that going in and saying, yeah, I want to buy a couple of joints or an edible to take home, and you guys just have the Plinko board out, right? Somebody's got to say play. Your bud tenders don't say, hey, you want to play Plinko, or how does that work?
It's not required. In fact, having worked there myself, some during some of these events, a fair number of people elect not to stand in line, and they just go straight to the point of sale in order to purchase whatever they intended to on their way in.
Yeah. So as long as a customer, somebody who plays Plinko, and of course everybody wins. You win, don't you? Or are there loser slots?
I would say some of our customers would believe that they had lost if they didn't receive the coupon that they had intended.
Yeah. Just like I didn't get a quilt at the Veterans Day thing in Bethel day before yesterday, and so I think I lost. So as long as the licensee, the retailer, is ensuring that a customer, with or without their winnings, are going over the legal limit for purchasing, I just can't see how having this Plinko game there is encouraging overconsumption. Now, somebody might, 50% off. Yeah, I'll take the biggest thing you got behind the counter. I'll take the, or it might be I want 50% off on that nice glass bong, huh?
They do both.
Yeah. So, we've talked about how businesses, and they are businesses, are able to promote their business, how they're able to develop some customer loyalty, and this is obviously, a customer loyalty tool. It is something that perhaps Mr. Schulte will agree we should consider a little more deeply or clarifying in regulations. But after I looked at this and read through it, I just can't really see that this is a particular violation.
Mr. Chairman, in a break with precedent, I'm gonna go for brevity. Question procedurally: if we simply vote to dismiss this NOV, does it remain as an NOV that just wasn't acted on, or is it an NOV that was dismissed, or does it just simply disappear from the record?
I think the proper thing would be for a board action letter to say that this was dismissed to go along with the NOV, because I think getting rid of something that permanently within the record, it does a disservice to the future licensees because it's not there for review. And what that does is if somebody asks if this is an NOV to be reported on, then we can say that there is no NOVs because this would be dismissed.
Mr. Chairman, my concern with that would be, earlier today we heard that, in some cases a record of NOVs can reflect negatively on these businesses, and these are businesses that have, investors and other people to answer to, and I'm looking for a way that, we without simply dismissing the legitimate concerns of enforcement, I would like to just see this go away.
If I may, Mr. Schulte, I appreciate the comment. You sort of beat me to the point because that was going to be my request of the board, given your anticipated decision here, in that, you know, it's one thing for AMCO and AMCO enforcement in our very small community to be aware that alleged notices of violations are just that until they're acted upon. But the public at large, other agencies, businesses that we hope to do business with, or municipalities that we're applying for license applications or transfers or whatnot, they all look back to the record as to see what NOVs have been received by a particular licensee, and those have sometimes they, you know, can have extreme financial and business negative business effects. And so I would ask that, you know, I wouldn't ask that we stricken from the record this conversation or this decision, but at least remove the NOV from our record.
Yeah, James.
I don't disagree with that. I just think that we need some kind of documentation saying that the reason why this was dismissed, and it would be as simple as taking this NOV, moving it from the active issued NOVs to another folder that says dismissed NOVs by the board. And any public requests or any notifications to any insurance companies and so forth, when they look in that folder, they would not find this particular NOV, and I think that would be the proper way to do it.
Okay, is everybody okay with leaving that technical process up to the director and our attorney to make sure that it's done properly? If
I would be okay with that as long as it were absolutely certain that in you know, other NOVs notwithstanding, that this one would not resurface in any sort of negative light. I would ask if the licensee's legal counsel is okay with that.
I mean, assuming that it's completely removed and not researchable or shows up anywhere as a notice of violation that's received by our license, I would be agreeable to that. I guess, sorry, just one thing. I think potentially, given the discussion from this morning's session and now this particular issue, it seems like this might be ripe for a discussion for a mechanism or a method for us to remove alleged violations from licensees' records altogether. But I'll leave that up to you.
And for the record, I just want to say I agree with that, simply because if you just get rid of it, it doesn't carry as much weight as if the judicial authority, in this case the Marijuana Control Board, agrees with the individual bringing it before the board that it was not a violation, then I believe that carries more weight than just kind of getting rid of it. I think it's a vindication in itself, and that needs to be reflected properly on the record.
okay, I think we can do that. I think we again, if we vote to dismiss the NOV, I think we can probably develop some correspondence from the board to the licensee. So, is there a motion on this NOV?
Okay, I'll take a stab at it.
Go right ahead.
So I move that the board rule this NOV not a violation, and that I mean the minutes of this meeting will serve as a record of this discussion. So I move that the board rule this as not a violation, and that it be removed from their official record of NOVs, and that it not be offered up or made available to any third parties. Leave it at that.
There's a second.
Second.
Okay, any discussion?
Mr. Chair,
Go ahead, Ms. Jones.
I'm going to vote no, simply because, not that I don't want to dismiss this particular one, but the motion or notion that this won't resurface or that it won't be researchable. There are a lot of, I can go out to court view and I can see who's been sued and the suit dismissed. I can see who filed for bankruptcy and it was denied. Having sat on hospital boards, I know that we have records of every, malpractice allegation filed against the doctor applying for privileges, and we know whether those were dismissed or whether they weren't. Not saying that this or any other notice of violation reaches any of that. If I get a parking ticket in Juneau and it gets dismissed, found. If I get a speeding ticket and it's dismissed, you can research it. You can also research that it was dismissed, but you can find it, and it's important, and it's used either for a defense or for an offense, depending on which way it goes. So, I don't mind dismissing it, saying we don't think it's a violation because of our interpretation of the regs, but I really do object to sort of saying this goes away and isn't researchable.
Yeah, thanks, Mr. Jones. Any other discussion?
Mr. Chair.
Sure, go ahead and introduce yourself to us.
Kevin Higgins, Assistant Attorney General. Public Records Act would prevent you from making it not searchable. You would need a legislative fix to say that it was confidential or that it couldn't be disclosed in that manner.
And I think that's the logic behind having a statement by the board that, in fact, it was dismissed. There's a record of why it was dismissed, which there is, and this record isn't going away. And so if somebody has got concerns, the dismissal is defensible both by us and by the licensee. But where do you go?
Who was that?
Yeah. He's another one of our lawyers. So, yep, thank you. And the same thing goes with court view, I think. Just think about the discussion that the legislature had the last session, I think it was, about trying to clean out court view. So. Go ahead.
Just to address sort of the overarching sort of thought process here, but if in this particular case, we've turned this communication between enforcement and the licensee as a notice of violation. Potentially we should consider a notice of alleged violation or something like that, because given Mr. Jones' example, there's no notice of felony or any sort of, there's a difference here between making a record of something that has been found to be true versus something that has been found to be false or not as charged. And when people research notices of violation, on their face, they sound like notices of violation. It doesn't sound as if it was just an issue that was brought up for potential violation. It says notice of violation. And so that makes it difficult as a business. I'm not sure what other industries within the state of Alaska do for this type of administrative enforcement, but this doesn't seem fair to the licensee.
Well, yeah, I mean, let's read the fine print here. It says, this is a notice to you as licensee that an alleged violation has occurred. If the Marijuana Control Board decides to act against your license under the provisions of, you will receive an accusation and notice of your right to administrative hearing. Note, this is not an accusation or a criminal complaint.
I understand, but that's a communication between the, AMCO enforcement and the licensee, not the public.
Sure. So anyways, the bottom line is we have a motion to dismiss the NOV with caveat that it was dismissed by us. The record exists as to why it was dismissed. We've been notified by counsel that, in fact, we do not have the ability to essentially hide the record. But again, I would say that if we dismiss the NOV, then you're able to say that it was dismissed. So, okay, any other discussion on the board?
Well, it sounds like you maybe need to withdraw and restate the motion, because I maybe should have.
If you have a better way to restate it and your seconder agrees, go ahead.
You okay with that, Nick?
Yeah.
Okay. All right. So I move that the board vote to find this alleged violation without merit and that it be dismissed.
Okay. We have that motion.
Second.
Okay. Any discussion on that? Okay, so we'll do a roll call. Mr. Jones?
Yes.
Mr. Miller?
Yes.
Mr. Jaime?
Yes.
Mr. Schulte?
Yes.
I'm a yes, so it has been, found not to be a violation and dismissed.
Thank you, Mr. Officer.
You're very welcome. Okay, let's move along to, NOVs for unpaid taxes. We got, what did I count, like 85 pages on the, header, 57 pages. How many of these have we received responses or, numerical notice from revenue? I know they don't tell us about individual cases, do they?
I'm not sure I understand your question.
Okay, are these guys all still in arrears?
I'm not sure. So at the last meeting, the board discussed how you wanted to address people with frequent delinquencies. You requested that if a licensee was delinquent for 3 of the last 6 months, you wanted them to come before the board. There's a whole list of those people later in the agenda.
Okay, very good. With that, we'll move on to tab 10, which is accusations. First one is Rainforest Farms LLC. So, Director?
Thank you, Mr. Chair. Back in May, I served an accusation on Rainforest Farms LLC for transferring their license without board approval. The Marijuana Control Board reviewed the accusation and held a hearing on August 20th, found that the licensee had committed the acts alleged in the accusation, and the board assessed a civil fine of $30,000 and then suspended $28,000 of the fine pending approval of a transfer of this license at the November meeting. We're at the November meeting, and the transfer is not on this meeting agenda because the applicant has not finished the transfer application. The board's action was conveyed to the licensee in a letter sent on October 9th, 2019 by email and registered mail. We did receive a return receipt for the registered mail. The licensee was provided an opportunity to appeal the board's decision with the standard 15-day deadline, which would have been October 24th, and I requested payment of the $2,000 fine by October 31st if the licensee did not appeal. We did not receive an appeal from the licensee, and the licensee has not paid the $2,000 fine. With regard to the pending transfer, they received an incomplete letter relating to the transfer application on August 23rd, listing corrections that needed to be made to the application. Under the regulations at 306.025E and F, they have 90 days to complete the application. That takes them to November 21st. However, I believe the board did make it clear in the August 20th hearing that they expected the transfer to be on this agenda. And again, it is not. So I bring this back to the board for your decision on what to do with the situation and the suspension of $28,000 of the $30,000 fine.
Okay, is Rainforest Farms on the line, or?
The conference is no longer in listen-only mode.
Okay, this is Marijuana Control Board. Somebody turn your music off, please. We're looking for Rainforest Farms.
This is James Barrett with Rainforest Farms. I'm here. I just can't hear over the music.
Okay, yeah. Okay, somebody's playing music in the background. Everybody needs your phone. Serious business.
I can't hear anything that's being said right now.
Okay, that's wow.
Rainforest, set that up, man.
Yeah, Aaron, we're gonna hang up. We're gonna dial the bridge back.
Deploy.
Welcome to the GCI Conference Center. Please enter your access code. Thank you. Please stand by. You will now be placed into conference. There are 90. Welcome to the GCI Conference Center. That entry is not valid. Please enter your access code, followed by the pound sign. Thank you. Please stand by. You will now be placed into conference. There are 67 participants in the conference.
Mr. Barrett and Mr. Bean, if you're on speakerphone, go ahead and get off the speaker. Everybody else, please mute your phone. We're talking to a licensee, Marijuana Control Board, talking to a licensee, so please have some respect. Thank you.
Mr. Chair?
Yes, go ahead.
My name is Mike Scarcelli, and there is just some audio issues, but I'm also on the line, and I am on WCC side, and we have a purchase agreement with Forest Farms.
Okay. All right. So, all right, I guess we'll start with Mr. Barrett.
Yep.
Okay, go ahead, tell us what's going on.
So we've been working on the transfer application, and as you guys know from a previous hearing, WCC was under a management agreement. Part of that agreement was to comply with all laws. They had failed to pay their local sales tax for the summer, and so we had repossessed the retail store. We have not heard back from WCC or anything, so they basically had abandoned the retail store. So now we are back running it, and we are no longer working with that group. That's the status right now. I have not heard from WCC, Mike, or Aaron Bean since we've taken over the store. We've inherited all of their employees, all of their taxes, and all of their debts, and have decided to run the business responsibly because they were not running it responsibly under the management agreement. So that's where we're at now. Regarding the $2,000 fine, this was my mistake. I was unaware that it was supposed to be sent in the mail already. I can send that in the mail today. That was 100% my fault, but we've just been transitioning in the last few weeks as we've learned of the inability for that proper management agreement to play out. So that's where we're at now. So I just ask if I could just have, the rest of the day to throw a check in the mail, and then we can end the transfer process between the two groups, and Rainforest Farms will ultimately just remain the license holder at this time.
Okay, so you're formally abandoning the transfer process.
Yes, sir.
Okay, yes, response to that effect. If board members got any questions on this, go ahead, Ms. Shelley.
So during this period, was the retail store being operated under a valid license?
It was operated. I had filed the taxes. I was told that they were being paid. It wasn't until the local assembly was looking at our license renewal and they wanted to protest it. That's when we found out that this group had not paid any sales tax. And my brother and I, who are owners of the store, were forced into a confession of judgment in which we had to, because we are license holders and it hasn't been transferred yet, ultimately that's taxes on us. So that's basically where we stand right now.
Okay, so let me just look at the director, make sure I'm getting this straight. There was initially a transfer application and during that period, the transfer had essentially taken place without our approval, and that's what the original complaint was. And we fined the licensee, and since that time, we're being told that they've abandoned the license transfer process. Sounds legit. They're still ready to pay the fine. Is there any complication of that you can see?
Mr. Chair, I'll have to review the hearing on August 20th for the discussion of the management agreement. Management agreements aren't reflected in the Marijuana Control Board's regulations, and I do recall not having one that was signed by both parties. I know the board discussed that in a great deal. I don't particularly remember that the board accepted that that was an acceptable way for the store to be operating, but I would need to go back and review the record of that hearing, because I just don't remember the board's conclusion.
Okay, but that's also moot, is that correct, Mr. Barrett? There's no longer a management agreement?
No, and whether or not they had an agreement or not, the people of that party were acting as assisting in management as we were working towards transferring the application, so there was a little bit. Ultimately, I have been responsible for everything that happens in that store. So when we found out that group wasn't complying the way that we had asked, then it terminated the agreement. So whether it was written in there or not, we did have an agreement with them to ensure that the operations of the store are up to par, and that included paying taxes. And so ultimately we had to make that decision to terminate any sort of agreement we had with them, because we did not come to any resolution of how that party was going to pay for the damages that have built up over the summer.
Okay, so I think that was a yes. All right, any, what, Jones?
Mr. Chair, I just wanted to make sure that on the record, since Mr. Barrett brought it up, I serve on the City Borough Assembly. When this issue of non-payment of sales taxes came before the Assembly, I did recuse myself, left the room. I was not part of the record. I certainly, like everybody else in Juneau, read the front page of the paper, made the paper, but I just wanted everybody to know that when the issue of local sales taxes, which wasn't part of this accusation, was up, I did recuse myself, because under previous rulings, if I had acted there, I would have had to declare a conflict here. I declared the conflict in Juneau. I just wanted to make sure that was on the record.
Okay, thank you, Mr. Jones, that's noted. Okay, so, what should we do here? We need a motion to, report, this is just a report on the status of the settlement.
No,
Okay, go ahead.
so you suspended a large portion of the fine pending a certain thing that is now not happening. So you need to decide what to do about that.
Okay, Mr. Barrett, we're gonna mute the phone, just keep the noise down. Go ahead and mute the phone, thanks.
The conference is now in listen-only mode.
Everybody, Schulte was on when we had this meeting. So the question is, do we let the $2,000 stand and accept that there's been a, Mr. Barrett and his brother have been unwinding the transfer in good faith, or what does the board think?
Mr. Chairman, it occurs to me that the original fine of $30,000 was predicated on the assertion that a transfer of the business took place without, but the transfer was abandoned. So I'm kind of leaning towards just dismissing the fine altogether. I mean, apart from that fact, sounds like they've been operating the retail store under a valid license, and they've probably incurred a lot of costs they weren't anticipating. So I don't see any value in even holding them to the $2,000, to be honest.
Any other discussion? Go ahead, Mr. Tommy.
I'm going to disagree with Mr. Schulte on this one. You know, the act occurred on the alleged date, so the violation occurred, he needs to be subject to the fine amount.
Okay, any other comments?
Mr. Chair, later on, when we talk about unpaid state taxes, I think it's tab 23, Rainforest Farms is there. I think the chart shows that they have not paid their state taxes on their grow operation. Now, granted, we're talking about the retail operation here. They're pretty close overall to about $100,000 in arrear on city sales taxes. And so I think that they have a significant enough issues. I'm not willing to dismiss the $30,000. I'm willing to accept the $2,000. I think the Barretts have a significant mountain to climb in the next 6 months if they're going to stay in business, period, without incurring so much debt. So I'm not willing to dismiss the whole thing. I'm willing to settle for the $2,000. I just think that this is a very troubled business that may or may not make it.
Okay, yeah, and I don't agree with dismissing the $2,000 fine either, so.
Can I make a motion?
You may.
So I move that the board accept the reduced fine of $2,000, payable, I would offer by the end of the month, and take no further action as far as this issue is concerned.
There's a second? Second. Seconded by Mr. Miller. Okay, so your motion is to just uphold the $2,000 fine, which should have been paid earlier, but, and otherwise, well, we can't dismiss the accusation, or let's see. We are, yeah, okay, yeah.
Well, no.
Yeah, that was basically the action. Okay, Director?
I was just going to say, you've already found that the acts alleged in the accusation were committed.
Okay, so we got a motion and seconded. Everybody understand the motion? Okay, Mr. Jones?
Yes.
Mr. Miller?
Yes.
Mr. Jaime?
Yes.
Mr. Schulte?
Yes.
I'm a yes, so motion passes. Which brings us to tab 11, parallel 64. And go ahead, Director.
Thank you, Mr. Chair. Parallel 64 LLC is a limited liability company owned 58% by Dimitri Amar, 20% by Anwar Amar Rogers, 17% by Travis Jones, and 5% by Stephen Richard Garcia. They hold a standard cultivation facility license for a business called Parallel 64 LLC, located at 2128 North Post Road in Anchorage. Their license number is 10174. Their license was first issued to them to begin operations on April 25th of 2017. On May 3rd, 2019, Anwar Amar Rogers transported 8,262.75 grams, which is 18.22 pounds, of marijuana from Parallel 64 in Anchorage to two other licensees located in Fairbanks by flying on Raven Air. Mr. Amar Rogers packed the marijuana in a plastic tote secured by 3 zip ties and a padlock and labeled the tote State of Alaska, care of Anwar Amar, with the registered mailing address of Parallel 64 LLC, which appears to be a box at a UPS store in Anchorage. Mr. Amar Rogers checked the tote as baggage during the flight. Because of a strong odor of marijuana coming from the tote, a Raven Air employee alerted the Fairbanks Airport Police, who informed AMCO enforcement. An NOV was issued. The regulations at 306.750, pardon me while I just pull that up. requires that marijuana be secured during shipment with the transporter, and this was a violation of that, and thus this accusation is brought before the board with a request that the board find the respondent committed the acts alleged above, and that the marijuana board issue a civil fine of $10,000 to Parallel 64 in accordance with 306-840, and for such other relief as the board considers appropriate. Attached to this accusation is the NOV, a photo of the tote, and the manifest that was with the tote.
Okay, thank you. Care to introduce yourself?
My name is Anwar Rogers.
My name is Anwar Amar Rogers. Last name is AMAR-ROGERS. I am the owner of Parallel 64.
Okay, so you received this accusation, and did you did he file a defense?
I don't have anything.
I filed here for a hearing as an appeal.
Okay. All right. Okay. Great. Okay. This is you were transporting where from Fairbanks, right?
From Anchorage to Fairbanks.
From Anchorage to Fairbanks. Okay.
I don't want to interrupt, so I guess let me. I'm here basically to do two things. I want to first explain the reasoning as to what we did, and also just to kind of clarify a few things in the statements and the accusations that have occurred. More importantly, I'm also here to ask for some leniency, because I do admit that there were some things that we did in error. So I'm here also asking to the board for, again, understanding and some leniency, and if allowable, to be able to kind of hear the discussion behind that. We were transporting some product from Anchorage facility to Fairbanks facilities. During that manifest and during that transfer, we found that not all of it could be carried on our person. Some of it, not all of it, did go into a plastic tote, into a rubber, plastic tote, sealed with zip ties, some locks. The photograph that was taken by the officer only shows an aerial view. There was additional locks on the side, but the main point of it was it was checked into to Raven Air cargo baggage, basically. Reading the transportation, a lot of these regulations are subject to interpretation. There is a little bit of gray in some of them. What we had kind of inferred from the transportation aspect of it was that if I were to secure it, if I was to accompany the package, if I was to, again, basically accompany the package and carry it all the way up to check-in point, that perhaps that would kind of suffice. We would be exercising some sort of control and supervision of the package all the way up to gate check-in. Obviously, 20/20 hindsight, after the NOV was issued, it was very clear to us that we can't do that. We can't check in a portion of the package, even if we feel that we have some sort of control into it in some capacity. It wasn't made clear to us until the 610 advisory notice, where there's actually language and verbiage that does say, also all transported marijuana must be secured with transporter at all times. Transported marijuana and or marijuana products must not be checked as baggage. Again, that was an error that we created on our part. We're here to, again, ask for some leniency and some understanding. It wasn't an act of maliciousness. This wasn't an act of complete disregard to the regulations. We've never sat here before the board meeting, so this is our first rodeo. So we try to be compliant. We're in good standing with the city, good standing with our state, good standing with our taxes. Again, I don't want the board to think this was a malicious or blatant disregard for regulations. This was probably, we kind of exercised probably some gray on one side, or maybe we should have stopped and maybe asked for clarification. It's very clear now due to the advisory notice, but nonetheless, we're here just to ask for a little bit of understanding as to the individuals behind the company and how we operate, and also some leniency and understanding as to the reasoning and the how as to where we went about that.
Okay, so how much product was in the tote, and you were carrying some as carry-on baggage also, right?
Yes, sir. Yes, sir. There was some waste product that was going to manufacturing that was put in the tote. A couple pounds, I can't recall exactly, but there was a couple pounds because we're able to, depending on carrier, we're able to transport as many as 30 pounds on our person on some carriers. Raven poses a little bit of a different logistics. We're able to carry, depending on also the product, if it's flour or you want to be a little bit more care with flour, so you don't necessarily stuff those in the packaging allowed. But it kind of varies from carrier.
Yeah, sure. Well, I think well, a couple of things. Number one, you essentially, when you checked into the tote, and I'm just asking this for edification, did you show the customer service agent your manifest? Did you tell them that this was marijuana that you were, I use the word attempting to transport legally?
No, sir. We did not disclose any of that business, and here's another reason why. Whenever we're transporting, we were one of the licensees in the state that actually got burglarized a couple years ago. We feel that some of that had to do with the fact that too much of our information was made public. So whenever we are making some transportations, we feel that there's only three bodies that need to be in the know of our transportation: the state, the seller, and the purchaser. So we try to keep, for security reasons, a very low profile as we move and we transfer product and we sell product. So we did not disclose to an agent that there was marijuana product in packaging.
Okay, what would you have done if you had gotten to Fairbanks and found out that not that Raven would do this, but found out that your this tote got bumped? Did you have a plan B? What would be the first thing you would do if that happened to you?
Because of the way that Raven Era operates, it goes on. And we were able to actually see at gate check-in, visually actually see it get on the belly of the plane. If we were to get bumped or removed from the plane, obviously that package would be removed with us. So there was a certain thought process behind it because it is being entered into a system that moves thousands, hundreds, millions of packages a day via checked luggage, cargo, etc. So I did not think that far ahead, but I also did not feel that the package would get removed or bumped without me knowing or in me accompanying it.
Okay, and just one other question for right now. What's this label business, State of Alaska, C-O-N-R-M-R? What was your intention there?
Two things. Again, going back to, we're trying to be transparent in the sense that by putting on the State of Alaska, the contents of it are governed, are highly regulated by the State of Alaska. I mean, hence why I'm here discussing to the board now. In no way was it meant to try to mislead. As far as my name was on there, my contact information, the business contact information, it all leads back to Parallel 64. We do try not to place Parallel 64 labels when we're transporting, because again, for security reasons, and also for the fact that before going back to the burglarization, we try to minimize as much information to the public outside of those that need to know, which again is the three parties: seller, buyee, and State of Alaska.
Okay, board members? Good.
Couple questions. So I see here you've got a manifest that lists, the point of origin, the destination, all the specifics that I believe are required of a transfer. And the reason you put in checked baggage was that there was too much to just carry on your person and put in the overhead?
That is correct. Raven Era actually has more minimal requirements for checked-in and checked-in luggage than, let's say, for example, another carrier. So yes, it was kind of restricted.
They're tiny overheads. So when you checked this, did you check it at the counter in the terminal, or did you check it on the ramp next to the plane?
Both. So I went through the process of going through the terminal, but we actually ended up getting it at gate check-in just by insisting there was no way they were going to let me on the plane with it, but being able to go through gate check-in was.
And the reason for the board members, there's two different processes that some of us are probably familiar with. The first one where you check in at the front counter, and they say, do you have any checked baggage? You give them your checked baggage, it disappears onto a conveyor belt. You don't see it again until it comes out on the carrier. The other option, which happens quite often, is people will show up with a bag it's too big or it's the wrong dimensions, and they essentially walk it out to the plane. And at that point, they surrender it to the ramp agent who tags it, puts it in the baggage hold, and then when you get to your destination, you walk out of the plane. They bring your bag to you, and you continue on the way into the terminal. So two very different situations, and I mean clearly there's they're very different situations with respect to custody. So is it that latter case that applies here, where you actually surrendered it plane side?
That is correct.
And you watched them put it into the baggage hold?
That is correct.
And then they out of the baggage hold and give it back to you?
That is correct. However, it went directly to, I think maybe from its size, it went to their typical baggage handling
carousel
area. Correct.
Yes, in Fairbanks?
That is correct.
Okay, so for a brief period, it was out of your sight?
That is correct.
Questions? Okay, just, in the NOV, it says that, the tote was secured with 3 zip ties and 1 padlock. And on the picture, I count 4 zip ties, but can't see the padlocks. And James, these are the photos that came from Airport PD?
Correct.
Okay, so what did Airport PD report to AMCO, this incident?
I believe they did contact Investigator Chiesa in Fairbanks.
Okay, and so that was the basis for the NOV?
Correct.
Okay. Airport Police released this to you, is that correct?
Yes, that is correct. In all fairness, maybe whether this matters or not, to be honest, the officer was not familiar with this process or had not seen this process prior that he had personally ran into. He actually just released it to me, no questions asked, after disclosing that I was a licensed cultivator with the state of Alaska. It wasn't until we got into a little bit more friendly discussions that it kind of led a little bit more into, hey, let me see your handler card. Do you have a manifest here? Yes, I have all the documentation here provided. But that's how it kind of occurred.
Okay. Go ahead.
Sorry, I should ask you this before. So you were reading to us before what I think you termed an advisory memo that says that product cannot be put into checked baggage.
Yes, sir.
I don't see that in here.
The advisory notice here, dated 6/10, actually from the Marijuana Control Board. It does state there at the bottom of the. I can provide this here for your record.
Yeah. So that advisory. So this all happened at the beginning of May. The advisory came out in June. Okay. So I guess I have a couple questions. For the board to consider, the advisory, first of all, is not in regulation. So would you have had access to that in May when you put this into gate check baggage?
No, because this did not come out until June, which kind of brings up a larger point, and I don't want to digress or diverge from the.
That's fine.
From what I'm here to answer for. the regulations, really this gives an opportunity to be able to actually revisit regulations and actually look at some logistical problems that Alaska has. Alaska, I think, is a unique state. We're separate from the other states, and where there's a lot of vehicular transportation abilities. We're in a state where we have remote locations all over the state where vehicular transportation is not impossible or not adequate, where we take into either aerial or barge transportation. And while the regulations somewhat talk about and really only address vehicular regulation or vehicular transportation, there's kind of that gray area where it's not very clear as far as aerial or other means of transportation. It would be a great opportunity to be able to actually visit that, make some things more clear. Obviously, based on our experiences, we're probably the one licensee that will never repeat this again, being that we got an NOV for it. But nonetheless, it is a great opportunity to be able to at least address those things. Again, I don't want to make this matter, that matter, but it gives you a little bit of thought and a little bit of depth into the thinking that we, when we made the decision to do what we did.
Go ahead, James.
I wrote the advisory notice. This is one of the main precursors for me writing that advisory following this. After talking with the investigators and some of the people, licensees, some of the people in the industry, we found that there was a lot more people that were checking marijuana as baggage, not carrying it on. So that raised a lot of concerns because not every single person that works on the ramp of an airlines or a barge or anything else is over 21. So if you have a checked bag with 10 pounds of marijuana and you have an 18, 19, 20-year-old taking that bag and moving it and securing it, two things are going on. The licensee isn't securing that as required by regulation, and we're allowing access to that marijuana by somebody under 21 that doesn't have a handler card. So there's a lot of concerns there. I see that there is room for improvement, but I remember that the board basically said the airlines, specifying things in airlines, and maybe the waterways, they didn't want to touch that, and they would address what they would in regulations. And I do see a problem with that, but I also do understand that a licensee should be responsible for securing the marijuana. We've all traveled and checked in baggage and arrived on the opposite end of where our destinations, and some of us have found that our baggage didn't show up with us. I mean, living out in Bush, Alaska, I can tell you probably 6 out of 10 times all of my baggage didn't go on the flight with me. So I do find it concerning that a licensee would allow or check in baggage regardless if it's on the ramp or not, and let that marijuana out of their sight. I also do find it concerning that State of Alaska was written on there. That gives a clear indication that it was the State of Alaska's property. That's what it looks like. And that was a concern of the airport police officer who called us and said, is this your guys' evidence? Is this your guys' stuff? Is he your employee? We had a lot of those questions. I will say, with Parallel 64, they are a decent licensee that is always open with us in communication. So when they tell us that they're not going to do it again, they realize that they've learned their lesson, I believe them. But that doesn't dismiss that this occurred, and this leaves a lot of questions. I mean, don't label your stuff as State of Alaska if it's not State of Alaska, and always secure your marijuana. Regardless of when that advisory came out, I think it's safe to understand that most licensees at this point knew that they are responsible for securing the marijuana.
Go ahead, Mr. Shuley.
I understand what you're saying. I'm not sure I agree with you on all points, because a couple things I find problematic. I mean, one is that an advisory notice went out that expanded on the regulations that the board was unaware of. The licensee is then being held to the terms of that advisory notice retroactively. That's problematic. I get your argument that under the age of 21 could be handling the product. That's an issue, certainly. On the other hand, are over 21, but the core problem here appears to be the notion that the product was out of his direct control for a period of time. It sounds like it was, only briefly. I do wish he'd put in, just in the overhead. He'd probably do it too at this point. But, I mean, every other aspect of this appears to have been, well-intentioned, properly done, totally above board, having been subject to, a criminal break-in. Totally understand how any business would want to try and minimize their profile in this transaction. I agree. It sounds like they probably wouldn't do this again either. I can't see that a huge fine is going to really benefit the state or anybody else in this process. It just seems like what I would like to see happen is see the regs revisited and have this stuff done through regulation, not more through regulation, less through advisories. That's all I have to say on that.
Okay, anybody else on the board got any questions or comments? Anybody want to make a motion on the accusation?
Okay, well, I would pose this as a question. My inclination is to, acknowledge, okay, this probably was a violation, however unintentional. I'm not really inclined to apply a fine to it, to be honest. I don't see there's any value. I don't think any harm was done. I don't see any value would be achieved by it. And as the licensee pointed out, our transportation in this state is a huge problem, and this is not going to be the last we hear of it. I don't have the solution right now, but I also don't see any value in taking it any further.
Mr. Ivey?
Personally, with Parallel 64, I mean, there has to be deterrence to, violating regulations. Your signage was completely incorrect, so I think there does need to be an assessed fine. Maybe not $10,000, but a minimal fine just for the rest of the industry.
Okay, so
Through the chair.
yeah, go ahead.
As the industry member, when I see things like this happening, it frustrates me. You admitted yourself you haven't been to a marijuana control board meeting since you got your license. That's part of your duty as being a licensee, to attend these meetings or at least review the notes and see what's going on. I do think $10,000 is an excessive fine. I do think there needs to be a fine assessed. We spent hours and hours in these meetings discussing transportation and getting in Southeast. And I feel like when you do things like this, you put the rest of the licensees at risk, because there is a process in place. We are transporting, but if we don't start following these rules, then maybe we won't be transporting through air carriers soon. So, but as a licensee, it is your responsibility and your duty to understand the regulations. So, the violation happened. I do believe there needs to be a fine assessed. I do think $10,000 is a bit excessive, and maybe someone smarter than me can figure out where the balance is. But let this be, for all licensees. When you do things like this, you are putting the rest of the licensees at risk in the state, and we need to be on our best behavior.
So is there a motion to uphold the accusation with a particular fine amount? Good, Mr. Lee.
Okay, so I would move that we uphold the NOV accusation and apply a fine of $1,000.
I'll second that.
Okay, I was thinking more in the lines of 2,500, but I'm going to have a little bit of bite here because go ahead.
The full amount is admittedly somewhat arbitrary. I mean, $1,000 is a chunk of change for me.
Yeah, I trust that what Mr. Miller said is taken to heart, not just by you. We have kind of danced with the transportation system in the state for some time to allow this. I mean, TSA danced with Fairbanks Airport Police. and Juneau Airport Police. So there's been a lot of understanding of what's going on by the transportation infrastructure. And I mean, this, I can think of a 4-letter word to describe this. Starts with a D and ends with a B. So I guess I won't oppose a $1,000 fine, because we need to recognize that this did happen and that it can't happen again. So, is there any other discussion on the motion? Okay, Mr. Jones?
Yes.
Mr. Miller?
Yes.
Tommy?
Yes.
Mr. Schulte?
Yes.
And I'm a yes, so the accusation is upheld with a $1,000 fine. Brings us to license 100977.
Thank you, Board.
Cab 12, Raspberry Root. Okay, good afternoon. Go ahead and introduce yourselves to us.
Jan Alpine, attorney for Raspberry Roots. Kim Cole, owner, Raspberry Roots.
Pardon me. Okay, Director?
Thank you, Mr. Chair. Raspberry Roots LLC is a limited liability company that is currently owned 45% by Kim Cole and 50% by Jerry Workman. When this situation is alleged to have occurred, it was owned 100% by Kim Cole. There has been a transfer between now and then. Raspberry Roots LLC is the holder of a retail marijuana store license, doing business as Raspberry Roots. It's located at 501 Raspberry Road, Suite 101 in Anchorage, with license number 10097. The license was first issued to Raspberry Roots to begin operation on April 11th, 2018. Kim Cole has been approved to provide a marijuana handler permit education course, first approved on April 27th, 2016, and reapproved on July 10th, 2019. On April 30th, 2018, the respondent, Ms. Cole, trained 2 new employees, allowing them to handle marijuana and make sales, although they did not have handler permits. The 2 employees applied for their handler permits on May 1st, 2018. A notice of violation was issued on May 3rd, 2018, and provided to the board at the June 2018 meeting. I, until yesterday, had never seen a response to the NOV. I think there was some miscommunication between the staff and the licensee, and I believe that the licensee's counsel has provided email correspondence. So what the NOV states is that on May 1st, 2018, at the AMCO office, Champagne Moore and Journey Malakini were talking together about how many sales they had made at Raspberry Roots on April 30th, 2018. They were at the AMCO office to get their marijuana handler permits and did not have handler permits on April 30th. The investigator who wrote the NOVs spoke to Kim Cole on May 2nd. She stated that she was training Champagne and Journey on April 30th. She stated that they had handled marijuana and made sales on the point of sales machine. This is a violation of 3 AAC 306-320, and I ask the board to find that the respondent did commit the acts alleged, and that the Marijuana Board issue a civil fine of $10,000 to Raspberry Roots and any such other relief as the board considers appropriate.
Okay, thank you, Director. Ms. Wilson?
Thank you. I provided a response to this NOV last week, and I just want to make sure the board has a copy of it. If not, I brought hard copies if any board members need a hard copy.
All the boards have a copy of it?
You did not get a copy of it?
Okay. I think we did.
I emailed it to
Yeah.
you. It's not in the meeting tab.
Okay, so, yeah, so that we read it.
So this NOV was 17 months ago, and as the accusation stated, and the director corrected herself, a response was provided to enforcement when the NOV was received. And some of the facts that are left out here in the accusation are kind of go to the heart of the substantial compliance issue. So this was 13 days into this retail operation operating, and as you can tell by the license number, it was a really early issued licensee. And so 13 days into the retail operation over the weekend, Kim had 2 employees take the handler card test. They both passed. And so she shadowed them and had them sign into the visitor log, wear visitor badges, and she was with them the entire time, or a staff member was. So the first day, they were doing training videos. The second day, they were learning how to input customer data into the loyalty program. And the third day, I believe it's the day at issue, when Ms. Cole, actually supervised them dealing with customers. And so that is what the heart of this NOV is. The NOV is a little bit disturbing in itself because the statements that were made, they don't say who overheard them making those statements. They don't say who reported it to AMCO. They don't say anything as to, like, where did this information actually come from. So that to me is a little bit concerning. The other thing that's concerning is this was 17 months ago. The NOV was 17 months ago. And it's just one NOV. So why this didn't come up at renewal, I don't know. Why the accusation wasn't delivered to us within a year of the violation, I don't know. But it kind of sets the tone that licensees, if they get an NOV at any point, no matter how long it's been, it can always come back and get them. It can always come back and hurt them. And that's a very unstable business model to live in. So, this NOV is based on a substantial compliance, whereas over the weekend, she was training employees, had them in direct line of sight, had them sign into the visitor log, and the one last step was to go to the enforcement office, which they did the very next day, and actually receive the permit card. So we would ask that this NOV this accusation be dismissed, because it has been a very, very long time. There has been no action taken on this for 17 months, and my client has not had any similar violations to date. And I also just wanted to acknowledge that Jerry Workman, the other licensee, he's here and he's present and seated in the front row if you have any questions for him as well. Kim, did you have anything to add?
No.
Okay, I've got a couple questions. First of all, for the director, this apparently this NOV was first.
Correct.
So why is it coming before the board now at such a late date?
Through the chair, Mr. Schulte, I think the board is aware that there was a serious investigation into a number of issues relating to both licenses held by cultivation and retail license held by Raspberry Roots, and an accusation against the cultivation license and this accusation against the retail license were written at the same time at the completion of the investigation, and then with some time that you heard about in Nome passing, and so the applicant or the licensee has requested postponement of the hearing on the cultivation license accusation in order to have sufficient time to prepare a response/defense. But this one, the chair and I discussed it, and it was determined that the response didn't need to wait for several months, so they sort of got separated.
Okay, thanks. I guess what I was asking is why did it take 17 months to get here from the infraction?
The report of the investigation from my enforcement staff brought these things, packaged these things together, and I addressed them together. I recognize it took me a long time to address them, but I addressed them together.
Okay, but then it was decided to break this one out and bring it to the board as a standalone accusation.
The respondent requested a delay for both accusation hearings, and that delay was granted for the cultivation accusation.
So just to chime in here, this Raspberry Roots' retail license has nothing to do with the cultivation metric issues, which is what the accusation of cultivation is based on. So I don't really understand why it took so long to get to this point, and it was in front of the board before at renewal time. So, and the board did not have any questions as to it.
So this specific issue was brought up?
The specific issue was disclosed in the renewal application, because every time we submit a renewal application, we include the NOVs from that renewal period. So this came with the renewal. This not the accusation, but the NOV at issue came with the renewal. And I would have to double check, but I'm pretty 99% confident we actually also submitted the response to the NOV with the renewal application as well.
Okay. So now question for you. I looked at this last night. What the training that took place, April 30th, I believe, 2018, was that a weekend or was that a Monday?
I believe that was Sunday.
Yeah, I could be wrong. Maybe somebody with a calendar could tell me. So here's where I was going with that. So the training took place on Sunday. They conducted some transactions, and then on Monday they went to get their marijuana handler's cards.
And also, at this point, Anchorage has Monday through Friday for handler card processing. Throughout time, it has kind of changed a little bit. At one point, it was Tuesday, Thursday. At one point, it was Monday, Wednesday, Friday. I don't remember at that time what the schedule was. But
I appreciate you pointing that out, because that's exactly where I was headed with
Yeah.
this, because when I went to get my handler's card, there was only, I think, one day of the week when I could go do that. So I'm trying to figure out what was the earliest opportunity after, for your staff members to go get their handler's cards.
The earliest opportunity that they could have gotten it was on...
Which was the day
May
after.
1st. Yeah, it was the day after.
Okay.
Okay, and you state in here that they had, of course, obviously they're going to get their cards. When did they complete their, finish the test and get that scored?
So we provided you the certificate in your packet. Exhibit C is one of them. But so for Champaign, it was on April 26, 2018. And for Journey, it was April 29, 2018. So a couple of days before the actual incident occurred.
They had their finger on the button over there?
No, I did. I just wanted to make a quick statement here, saying, I think all on this, as far as 17 months is unacceptable. We want to hold you guys to a standard. We need to be held to the same standard, if not higher. But having said that, a violation did occur, so I do think a fine amount needs to be assessed, a small one. But, and I apologize for 17 months.
Can enforcement shed any light on this length of time? I mean, as the director said, there were two concurrent issues here. One's a fairly complex one, but
I don't have an explanation for the time other than there was a lot of things going on with their other license. I do want to clarify for the record, at that time it was Tuesday, Wednesday, Thursday when we had our criminal justice tech doing the handler cards. And the individual who issued the handler card, Jason Davies, is the one who actually overheard these two saying they made sales prior to him issuing them a handler card, which he identified as a violation of regulations, and he reported that to us immediately. So I want to clarify for the record, so that shows some substance. So it wasn't just some random individual who overheard something. This was somebody who's familiar with our regulations and the issuance, which is his job that he's charged to do, to issue these cards. I do realize, and I agree, 17 months is a long time. It's a long time for us to reach back and think back to this incident itself. I do want to clarify for the record, though, the NOV was issued on May 2nd, or it was written May 2nd, sent to me for review, and delivered in person on May 22nd. And the response that Kim Cole is saying she responded to occurred on May 7th, prior to the NOV even being written. So I don't know how that quantifies as a response. She did ask an investigator, and when she didn't get an immediate response from myself or another investigator, she emailed another investigator, which created a lot of confusion. And if you look at Ms. Weltzien's exhibits as she presented them, they are very confusing, and one page is misleading at best. That doesn't show the correct, it shows it as one email string when that's not how it occurred. And I guess what it boils down to is Investigator Ruggs did say that she is not required to respond, which she isn't, as the board determined, and he found that her response was adequate. What I do want to say is she didn't follow the instructions on the NOV by responding and sending a response to amco.enforcement@alaska.gov, which that response never got onto the record, never got presented to the board, and I actually never saw that response, actually her asking if it was a response until 2 days ago. So I just want to clarify for the record that this, in my mind, was unresponded to at that point in time.
So just to respond to that, I'm not sure which of the pages Chief Holster is saying is incorrect or whatnot. So there was an email on May 7th, 2018 at 1:24, and you have that, and then another email provided on the same sheet at May 8th at 1:34 p.m., and then on May 8th at 7:56 p.m. And then the June 20th email, which is the email where Officer Rooks responds and says, yes, this is a good enough, sufficient response. It goes, hi, Kim. Well, first the question is, hello, Mr. Rooks. Hope all is well. I just wanted to touch base with you regarding NOV AB 18-475. Since the correspondence was prior to receiving the official document, I didn't know if I should send an additional response to satisfy the Marijuana Control Board. Thank you, Kim Cole. To which he responds, hi, Kim. There is no required response for a marijuana NOV. Still a good idea to give an explanation, though, and yes, what you sent is sufficient. So I apologize for the stream of communication, but I'm not sure how on this end we're supposed to facilitate that other than just corresponding with staff. Maybe if there's an email address you always want us to copy.
The instructions on the NOV are very clear. They give the email address on what a response should go to. So I realized this was a mistake, and it pointed out an internal communication issue that we had that I will address. I will address it to my investigators the next meeting that we do have. But I don't want this to cloud the issue that we had two individuals that were hired that sold marijuana prior to them having handler cards. That's the bottom line.
Thank you.
I just wanted to say that I could read what you sent as sufficient, meaning the content of your explanation was sufficient. I think that it could be confusing I think the interpretation of that direction can be confusing.
I'm troubled a little bit because I don't think anybody's denying that there was some level of violation that took place. But they self-disclosed it. I mean, they came forward, they went through all the necessary steps in the wrong order. But their transgression. And I wonder. I guess I'll put this as a question. There's Mr. Holster. I mean, was there ever any discussion at the AMCO office of like, oh, okay, yeah, they messed up. They made it right the very next day. We're going to give them a warning or a notice like, hey, you don't do this again. This is not okay. Short of waiting a year and a half and then landing an $10,000 fine on them. It just it seems a little much so far after the fact, and particularly, going back to earlier discussions today. A lot of the licensees, we've heard that licensees are reluctant to disclose problems or even ask certain questions because they're afraid they're going to get hammered. And to me, $10,000 is a big hammer.
So there was no self-disclosure on this. It was our criminal justice technician that overheard Ms. Cole's two employees while they were getting their handler card. They were discussing all the sales they made the previous day, being before they had their handler card. So then Mr. Davies notified enforcement. I went and talked to Ms. Cole, and she admitted it. She provided video. I viewed the video. At that time, I told her we're going to give her an NOV for it, and that's why I believe the response came before the actual NOV reaching her. And then she asked me if it was okay for a response, and I said yes, thinking it was. And I believe I forgot to forward it to our criminal justice technician, and that's why it didn't end up in the file.
Through the chair, can I ask Officer Rooks a question? Well, how come in the NOV you didn't identify who overheard? Why didn't you say and you don't have to say the person, but just like an enforcement officer or an enforcement agent overheard? Like not even the person, just...
The notices of violation, they're just a small summary of what occurred, just small summary facts. We have reports that normally go with them. To get the whole story, you have to read the report. You have to look at all the evidence. You have to watch video. You have to listen to audio. You have to get the whole case before you can make a decision.
Thank you.
Mr. Chair?
Yes.
I'd like to just make a comment regarding the $10,000. So the board's regulations at 3 AAC 306-840B say that in a proceeding under 3 AAC 306-810 through 830, in which this is an accusation, as this is, the board may impose a civil fine not to exceed the greater of an amount that is 3 times the monetary gain, 2, $10,000 for the first violation, 3, $30,000 for the second violation, or 4, $50,000 for the third or subsequent violation. The board has the authority to set the fine amount, and that is very clear. The only guidance that is given to me in suggesting a fine amount is this section. So that's why it says $10,000. I recognize that the board, I don't think the board has ever assessed the exact amount of a fine that I've recommended. In one situation, I didn't even recommend a fine, and you assessed one. In a lot of other situations, you've reduced them. That's great. That's your authority. But I'm using the guidance set forth in the board's regulations as just a starting point. So I just wanted to put that on the record.
Through the chair. So we've seen this NOV at least once, renewal, maybe twice through an agenda when it was issued. It's been 17 months. The NOV that was issued has consequences, negative consequences for businesses. And nothing against Jana here, but you know, a 17-month-old NOV is costing this business again more money. You know, prepping all this paperwork. That being said, I would like to make a motion to dismiss the accusation. NOV stands as issued. They did commit the violation, and you know, it's been 17 months. I think it's time to move on. So.
Is there a second?
I'll second.
Okay, any discussion on the motion? Not seeing any. Pardon me, on the motion to dismiss the accusation and maintain the NOV, Mr. Jones?
No.
Mr. Miller?
Yes.
Mr. Jaime?
No.
Mr. Schulte?
Yes.
And I will vote yes. So 3-2. So the NOV stands. Yeah. Let's come back at 5:15.
Welcome to the GCI Conference Center. Please enter your access code followed by the pound sign. Thank you. Please stand by. You are being placed into conference in listen-only mode. There are 48 participants in the conference.
Okay. Well, I like that. Okay, we're back on the record. 3:13, I shorted everybody 2 minutes. Okay, we're on to tab 13, which is handler permit revocation for Quincy James Ayatunguk. Director.
Thank you, Mr. Chair. This is a request to revoke the handler permit issued to Quincy James Ayatunguk, number 17827, on October 29th, 2018. 2013, Mr. Ayatunguk was arrested at the Ted Stevens Anchorage International Airport. He confessed to concealing 8.8 grams of heroin in his rectum. He was charged with a Class A felony offense of manufacturing or delivering any amount of a Schedule 1A controlled substance and possessing any amount of a Schedule 1A controlled substance with intent to manufacture or deliver. Mr. Ayatunguk is a manager of Good Leaf Organization Retail Marijuana Store in Nome, license 11119. He was intending to travel to Nome and was transporting marijuana from Alaska Weeds, license 14083, located at 620 Mike Street in Anchorage, to Good Leaf Organization, located at 303C West E Street in Nome. Mr. Ayatunguk's shipment had a metric manifest, but did not state the correct order. And an NOV has been issued to Alaska Weeds for that. AMCO retrieved the marijuana from the airport law enforcement and returned it to Alaska Weeds. I request again that the board revoke handler permit number 17827 issued to Mr. Ayatunguk.
Okay, is there a motion?
I'll make a motion to revoke handler number.
Second.
Second.
Okay, any discussion? I'll just say that there are a couple of cautionary tales here. Please know who's transporting for you, especially after rural Alaska. I was going, and believe me, his 8.8 grams of heroin was worth a heck of a lot more than he was hauling. And say thank you to enforcement for James for responding so quickly and getting the product back for the shipper. So, on the motion, Mr. Jones?
Yes.
Mr. Miller?
Yes.
Mr. Jaime?
Yes.
Mr. Schulte?
Yes.
And I'm a yes, so that handler card is revoked, and that will go on the website. Brings us to tab 13. Which is granting peace officer powers under Alaska Statute 1738-131 to Investigator Harry Lee Conway. Director?
Thank you, Mr. Chair. We've had a vacant Special Investigator 1 position in Fairbanks for several months now since the departure of Amanda Stonecipher. We have hired Harry Lee Conway, and Butcher briefed you about his background during his enforcement report. Under AS 1738-131, it states that the director and the persons employed for the administration of this chapter may, with the concurrence of the Commissioner of Public Safety, exercise the powers of peace officers when those powers are specifically granted by the board. So this request is for the board to grant the authority to exercise peace officer powers at such time as concurrence is received from the Commissioner of Public Safety to Investigator Harry Lee Conway. I would also point out that the Marijuana Control Board's regulations do not address the authority for investigators to carry firearms. Those are addressed in the Alcoholic Beverage Control Board's regulations at 304-505B. And yesterday, the Alcoholic Beverage Control Board voted both to authorize Mr. Conway to exercise peace officer powers under Title IV and authorized him to carry a firearm. And I should clarify, under Title IV, once we receive concurrence from the Commissioner of Public Safety.
All right, thank you. Is there a motion?
So moved.
Okay, who was that? That was Mr. Jones. Okay, is there a second? Okay, discussion. All right, all those in favor of granting, those in favor of the motion to grant peace officer powers with concurrence of the Department of Safety to Harry Lee Conway, Mr. Jones?
Yes.
Mr. Miller?
Yes.
Mr. Jaime Schulte? And I'm a yes, so that is granted. Thank you very much. Which brings us to the licensing report.
I have my standard statistics that I've provided to the board. I would like to point out that I did make a error. It states for regarding the transfer licenses, for the timelines in the bottom portion, that there was only one transfer submitted in this time period, and that was from my previous report, and so there had been multiple transfers submitted, so the statistics would be potentially less skewed for those than they were last report. We have had some staff changes since we had promotion within the office. We have a new examiner, and she is working right now on alcohol, and once her training is complete and renewal season for alcohol is over, we'll be our new marijuana examiner, who will be coming from our alcohol team, is the anticipated staffing change at that time. I'm happy to take any questions.
Okay, any questions? Okay, thank you very much for that. Okay, which brings us to item that we call consideration of an action previously taken by the ABC Board. It's no secret that the ABC Board took a fairly significant action, October 3rd, so I will ask Ms. Wilson, who served as counsel to the ABC Board, to brief us on that action, at which time I'll ask her to step aside and ask Mr. Kevin Higgins, Assistant Attorney General, to come up, and if the board requires counsel, we will be seeking.
Well, I represented the board at its special meeting. The board, the ABC board, voted unanimously in favor of removing the director, although very kind words were said about her at the same time. It was a lack of competence final vote. For purposes of conflict of interest, we want every board to have an attorney that they can speak to candidly, which is why I've been sequestered from this issue, and you're being ably advised by Mr. Higgins. I'm going to leave the room and actually leave the building. I don't want any appearance of any kind of conflict. So, Michael, if you could call me back when the matter's resolved.
Okay, thank you very much. Mr. Higgins, come on up and go ahead and introduce yourself to us again.
May I add, he's another Cubs fan, so you have a Cubs fan attorney.
Okay.
All right.
Well, just go ahead and introduce yourself, Mr. Higgins.
Kevin Higgins, Department of Law, Assistant Attorney General.
Okay, thank you. All right, so consideration, is there any consideration of this action?
Well, I guess my question I have is I guess the question I have is a preference to move it into executive session or have this in open hearing?
Okay, without a motion, let me just say, well, let me do this, or actually, Mr. Higgins, could you go ahead and review with us Section 1738-140 and Section 1738-150? Go ahead and read those to us, if you would, please.
140 and 150?
Yes, sir.
Title 17, Chapter 38, Section 140, Appointment and Removal of Director, Staff, Subsection A. The Director of Alcohol Beverage Control Board appointed under Title 4 shall serve as the Director of the Board. The Board may remove the Director by a majority vote of the full membership of the Board and a majority vote of the full membership of the Alcohol Beverage Control Board. Governor may remove the Executive Director as provided in Alaska Statute 0406070, Subsection B. The paid staff of the Alcohol Beverage Control Board created in AS 0406010 shall also be the staff of the Board. Title 17, Chapter 38, Section 150, Duties of the Director. The Director shall enforce this chapter and regulations adopted by the Board. The Director shall issue, renew, transfer, suspend, or revoke all licenses and permits and issue product approvals at the direction of the Board. The Board may delegate to the Director the authority to temporarily grant or deny the issuance, renewal, or transfer of licenses and permits. The Director's temporary grant or denial of the issuance, renewal, or transfer of a license or permit is not binding on the Board. The Board may delegate to the Director any duty imposed except its power to propose and adopt regulations. Stop.
So, asked him to read that to us so we understand what they have to consider. So I listened to the alcohol board meeting, and actually 2 of the alcohol board meetings. I certainly have my own feelings on the results. So with that, does any board member care to make a motion regarding consideration of the previous action by the ABC board?
Mr. Chairman, I move that Marijuana Control Board uphold and concur with the decision of the Alcohol Board to remove the Director.
Is there a second?
I'll second.
Okay. Discussion. Julie?
Well, I would just say I have no unkind words to say. I just, from what I have seen and heard of the last 2 meetings that I've attended, I think that a change in leadership is appropriate at this time.
Any other board members with comments?
Mr. Chair?
Oh, sure. Yeah, go ahead.
Just because the Open Meetings Act does apply to this, thought we should make clear that the notice of this topic was provided to the Executive Director, and she was given the opportunity to have this part of the discussion held in executive session, but she elected, as is her right, to have it held in public.
And Director, that's correct.
I can confirm that notice of this being on the agenda was given to me, and that I was told that should the board make a motion to go into executive session, I would be offered the opportunity to decide whether I wanted the discussion to be on the record. To avoid unnecessary procedural motions, I would state that I would have it on the record, so there's no need to make any attempts to go into executive session.
Okay, thank you. Jones?
Yes. I did not listen to any of the tapes of the ABC board. I read what was in the popular press, if that's a good term to use for any of the newspapers I particularly read, or tweets. I disagree with Mr. Schulte. I don't think there's any reason for the director to be removed at this time. I have not experienced, and like Mr. Schulte and Mr. Springer, all except for one meeting, I've been on this board since the inception. The second director, and I think that there was, and having been a director that worked for boards, I guess I have never seen a director always have the confidence of the persons that they have regulated, and boards have a tough time with that, but that is not any reason to remove the director. I think she has, in my estimation, done a terrific job. She has led us through a lot of things that we as a volunteer board need help with. We are not there full-time. We are not an executive board. We are not a board that does the day-to-day operations, nor should we be. And if we think we have that expertise, then I think we've got an inflated view of ourselves. And So, I don't see any, rationale at this point, from the marijuana board, to have the director, in any way, removed, from her position.
Thank you, Mr. Jones. Mr. Timmy?
Yes, this is a extremely difficult, decision. There's personal feelings involved, but ultimately we have to do what's best for AMCO, So, the AMCO director needs to be objective and receive support from both boards, and unfortunately right now, she doesn't have it. So, I'm gonna be a no vote. Hold that. Wasn't the motion to...
The motion was, or was,
Oh,
yeah, I'll call for it.
I will concur.
Mr. Miller?
I agree, this is a difficult decision. There are a lot of emotions, involved, but I think anyone who has participated in the last two meetings have heard about the extended timeframes to get things completed, responses from AMCO. I believe it's costing the industry and business owners money, and time that are unnecessary. And, to be honest, I don't know where I'm going to vote right now, but I do believe it is time for a change, and we should deal with it.
Okay, thanks, Mr. Miller. So, first of all, for the record, I have not received, the chair has received no communication from the ABC board regarding the action that they took. No correspondence from the chair of the ABC board. No formal notice has come to this board that they took that action. We're going by what we read in the papers and, of course, what we were told by the ABC board's counsel, which I guess counts as notice. I've been on the board since July 2015, and I have to say that Erica, when she came on board, she grasped the program pretty quickly. People say, oh, she's too bad. Look at the environment she came from. She came from planning and zoning. Everybody in here that's a property owner or a property renter, do you want wishy-washy? Do you want bendability in planning and zoning? Maybe you do, but, to her credit, she has, to her, belief that laws are there to be enforced, and regulations that were made by this board are there to be enforced in a proper fashion. Nobody anywhere is ever 100% happy with their boss, and nobody anywhere, it doesn't matter what industry you are in, ask the chemical industry what they think about OSHA. Ask an airline pilot what he thinks about the FAA. Ask somebody who's trying like heck to get a Medicaid bill put through what they think about the Division of Behavioral Health. Ask somebody that just got pulled over by a state trooper what they think of the Alaska State Troopers. Everybody's got a gripe, with the regulation of things. Our duty as board members of the Marijuana Control Board is to the people of the state of Alaska to carry out what it says there in the statute, which is very simple, to regulate the cultivation and consumption and cultivation and sale of marijuana consumption. I have had the privilege of working pretty closely on a very regular basis with the director, and she has always been on top of the issues and has, known what we're talking about, and I think she's done a damn good job of running it. We have 345 licensees, okay? It's a $380 million industry. Not everybody's not going to be happy with what happens. What do you want? No regulation? You want to just, you you want to move closer to what the black market is, or do you want to move away from what the black market is? And I think that Director McConnell has done a very, very good job of leading the office, of leading the staff in licensing and review and bringing stuff to us and supervising enforcement. So, as I said, I haven't received any contact from the alcohol board. I have been approached on a couple of occasions by the administration saying, well, are you guys going to have an executive session? Can we talk about this? Can we, if the alcohol board does make a decision, how soon can you have a meeting? We'd like to know what the plan is, and personally, I think that's very inappropriate. We are a independent, semi-judicial board, and we are the ones that make the decisions, and, I support the director. I'm going to vote against this motion. I am not done counting votes, clearly, from some of the comments here. I think that this has been, in some cases, something of a railroad job, based on the fact that people can't play music in a distillery tasting room. The alcohol issues, like if you read the paper, we've got 4 times as many alcohol licensees in the state. Alcohol is a powerful, powerful business in this state. They generally get what they want. And, sounds like they're getting what they want here. I've used the term that there's a war in heaven, and maybe I don't see the entire scope of it, and maybe the rest of us don't. But as far as I'm concerned, Director McConnell has done a very, very good job for the people of this state and for the industry, for the marijuana industry, and probably, grudgingly, they would have to admit for the alcohol industry, is one of the victims of that. Any other discussion on the motion? And I apologize for not being as eloquent as Mr. Jones. Okay, we ready to vote? On the motion to uphold the action of the alcohol board dismissing the director, Mr. Jones?
No.
Mr. Miller?
Yes.
Mr. Jaime?
Yes.
Mr. Schulte?
Yes.
And I am a no, so the motion passes 3-2.
Mr. Chair,
You're recognized.
I would like to make a statement.
Please do.
Thank you. Around August 26th, I became aware that Assistant Commissioner Amy Demboski was contacting Chair Klein and Chair Springer to ask that each board hold an executive session to discuss personnel issues. As the board have personnel authority only over me, it was clear that the administration was requesting that the boards remove me as director. As expected, during my agenda review meeting with Chair Klein on August 29th, he asked me to put an executive session for personnel issues on the end of the agenda for the September 10th ABC meeting. He told me that part of the reason he wanted an executive session was to talk to the other ABC board members about Bruce Schulte. After our agenda review meeting, I emailed Mr. Klein to ask him if I should inform Mr. Schulte about the executive session in order to comply with requirements of the Administrative Procedures Act that allows an individual to request a public discussion. I also asked him if there were any other personnel who needed to be notified under the Administrative Procedures Act. He responded, quote, "It is not my intent to discuss personnel, but I appreciate the heads up," close quote. Upon expressing my confusion because he had requested an executive session for personnel issues, Mr. Klein responded, quote, "We'll be fine. Thanks for worrying," end quote. At the September 10th meeting, after a motion was made to go into executive session with me, and after I requested a public discussion, Chair Klein inexplicably continued to attempt to mislead me by asking, "Why do you think this is about you?" Mr. Brady, another ABC board member, immediately confirmed that it was. Rex Leith, who serves as the public safety member on the ABC board, made accusations against Chief Holscher regarding AMCO's ORI number and against myself for improper supervision. Mr. Leith said he came across the information about the ORI number just that day and in the normal course of business. He also told me that attempting improper access to criminal justice information was a criminal act, which felt very much like a threat. As you know, the ABC board gave me time to talk to Chief Holscher about the situation and did not take any action regarding my employment on September 10th. Immediately after the NOAM board meetings on Monday, September 16th, Ms. Milks called to inform me that she had been reassigned and would no longer be serving as counsel for the ABC and the MCB. No reason was given to her, but she was told that it came from the top. I found this very alarming, and I immediately wrote to Ms. Milks' supervisor, the Attorney General, the Deputy Attorney General, the Attorney General's Chief of Staff, and the head of the Civil Division in the Department of Law, asking why they reassigned Harriet. I have not received any response from any of those individuals. Why did the administration reassign Ms. Milks? She had been counsel to the ABC board for over 7 years and counsel to the marijuana board for the whole of its existence. I believe nobody in the state is more knowledgeable about alcohol and marijuana laws. She had done nothing wrong in advising the ABC board on how to follow the Open Meetings Act. There has yet to be any explanation from the administration for this action. The allegations made by Mr. Leith were shown to be baseless. The ABC board stated they were satisfied with my explanation. Yet at the October 3rd special ABC meeting, Mr. Leith stated he couldn't remember when the ORI issue came to his attention, but he had found out about it by overhearing talk in the hallway. I find it highly inappropriate that a board member would use hallway gossip to make accusations at a board meeting rather than just picking up the phone to call me. The only conclusion that makes sense to me is that the ABC board was looking for a reason to fire me. So though Mr. Leith's accusations came to nothing, the ABC board made a motion to remove me, concluding that I had lost the board's confidence, disconnect between the board's desires and how I approach my position, and a lack of confidence that the board's will is being enacted. In addition, Mr. Brady blamed the action of Commissioner Price in refusing to communicate with me on my personality. At no time has the board suggested to me that I was not acting in the board's interest or was incapable of enacting the board's will. At no time during my many meetings with Chair Klein has he raised this as an issue with me or indicated to me that the board had any concerns with my work or how I approached my position. In fact, Mr. Klein stated on the record that their action was, quote, not a denigration, end quote, of my job performance. However, all 5 board members agreed with the motion, as shown by their unanimous vote, even though there was no discussion of what the board's will was or how they determined that I would not be able to enact the board's will. And 2 of the 5 members didn't even have any comments during the 2 minutes of discussion on the motion. It was abundantly clear to me that the board had previously coordinated their decision to remove me, as this had not occurred in a public meeting or in an executive session of which I was notified, and I believe this was a violation of the Open Meetings Act. And now, 3 of the 5 of you have voted to remove me. You have not you've not informed me of anything that I have done wrong, and in fact, all you have really said is you want a change in leadership for some unknown reason. Neither board has made, quote, reasonable efforts of temporary duration to correction in inadequate performance, end quote, as set forth in the State Personnel Act. Neither board has indicated to me that I have not followed their direction. This shows that you are not acting in good faith with me. An employment relationship is based on good faith, and those of you who have voted to remove me without actually finding that I've done anything wrong or providing me with an opportunity to correct any issues you have with me should be ashamed of yourselves. Public servants with integrity like Ms. Milks and me and the AMCO staff should be respected and appreciated, and instead we've been treated like dirt. These facts also give additional weight to the suspicion that the drive to remove me initiates in the administration. Ms. Dembowski's calls to the chairs in August and the ABC board's setting of an executive session trumping up false accusations against me and my staff are further evidence of this. Ms. Milks was reassigned by the administration and no reason is provided. Then the ABC board fires me in bad faith. I would like to remind you that the Supreme Court in Sabre Jet Room versus Beal, I'm not sure how to pronounce that, has ruled that under the state constitution, the legislature created the ABC Board and gave the board full powers and duties to regulate alcohol. The court ruled that the regulatory agency is not under the authority of the executive. Any interference by the administration, including the governor's office, the commission of the Department of Public Safety or her staff, or the Commissioner of Commerce or her staff, is an unconstitutional encroachment upon entities falling squarely within the legislature's domain. But the deed is done, and I walk away with my head held high. This is a very, very challenging job. Alcohol and marijuana are substances that have profound effects on Alaskan citizens and communities. Implementation and enforcement of the statutes and regulations should not be assigned to a political crony of the governor. There's no such thing as a perfect AMCO director, and I certainly don't claim to have been one. I've made mistakes, and many of them have been aired at board meetings in front of the public. All I have done is my very best to uphold the laws of this state, and if that's not the will of the boards, then I really question their motives. I worked hard, been supported by amazing staff, but without adequate resources, in the face of vitriol and slander sufficient to distress even the most stoic person. Perhaps you and the ABC board think that there is a deep pool of effective administrators who would step into this position, so tossing out a competent director is not a big deal. I believe you are wrong in this. Removing your director without real cause and stating after the ABC board stated on the record that my work ethic and job performance were appreciated is not good government for the people of the state of Alaska. I would like to thank Chair Springer, Mr. Jones, and the AMCO staff for your hard work and dedication, and I wish you the best for the remainder of the meeting.
Thank you, Erica, and I appreciate everything you said there. For a motion to, we'll just stand and recess until 9 o'clock tomorrow morning.
The chairperson has disconnected. The conference will now end.